The author in a article published in a national publication indicates that an automobile should never be put in a revocable living trust. Oh my, have I been wrong this whole time? The details after the introduction. So in today's video, I'm going to do something that's quite different from what I've done in the past. And that is I'm going to respond to one article that was published on MSN.com. You can see a copy of the article here, and it is entitled Five Things to Leave Out of a Revocable Living Trust. I would be remiss if I didn't thank my client, Gay, for forwarding this article to me. And I appreciate very much that he did. I did receive the article from a number of other clients, though. What you're looking at now is my blog article responding specifically to this particular advice. And in order to make it quick, if you don't want to watch the rest of the video, I explain in that article why you should never construe articles that are published publicly as good legal advice. I then discuss in some detail why I don't agree with this particular advice. First of all, transfer upon death designations or simple written instructions to avoid probate don't always work, and more importantly, have severe disadvantages and limitations, all of which are resolved by a properly drafted revocable living trust. Second, lifetime planning advantages of a revocable living trust are lost when any asset is left out of the trust, specifically with regard to that advantage, but even the whole objective, such as guardianship protection of assets, may be compromised by leaving any asset out of a trust. And fourth, avoiding probate for titled property is usually not simple and easy as is represented by the author, especially in states that have specific titling requirements for automobiles and particularly airplanes. Lastly, the liability issue that is raised by the article makes no sense to me whatsoever. In most states, a revocable living trust is not an asset protection device, and so leaving the car or vehicle in or out of the trust makes no difference because the assets in the trust are available for any obligation or liability that you have. Makes no difference. So let's get to the specifics of the article itself. It doesn't have a lot of information and it doesn't have a lot of explanation. It's actually a pretty simple statement. It says, and I'm going to quote, vehicles, whether it's a 63 Corvette, Harley Chopper, or prop plane, all that is required to pass it on is a simple written instruction to transfer the title to a beneficiary. In a trust, you're exposed to lawsuits over accidents that involved the vehicle. So the first thing I want to mention about these articles, and this applies to any article in mass publication or any information that is provided in a mass media format. That includes radio shows and TV shows. They do not and cannot constitute legal advice, and you should not take them as such. How do I know this? Well, because the author or the speaker does not know you, and they don't know your information, your circumstances, your goals, your objectives, your needs. An attorney who represents you in dispensing legal advice goes through the process, somewhat arduous process at times, of making sure that they know all of your circumstances, your goals, your objectives, your needs. We do this by an initial conversation or consultation with you. My clients know that this consultation takes at least an hour in most cases, and in many cases takes more than 2 or 3 hours. There are many instances in which we consult or converse for 2 hours and then break and then begin another day when we have more additional specific information regarding a particular subject matter. The reason that I ask all of these questions that are included in my initial consultation is not because I'm nosy, and it's not because I just want to know everything about all my clients so I have things to talk about. It's because it's necessary in order to properly advise them with regard to their estate plan. Most of my clients are going to tell me no to a lot of questions, like whether they have a business, whether they operate rental properties. They're going to tell me, no, I don't invest in cryptocurrency or Bitcoin. They're going to tell me, no, I don't have an interest in an oil gas well or a lease. They're going to tell me, no, I don't have beneficiaries that are disabled or incompetent or incapacitated or receiving government benefits. But the answers to these questions is going to determine how I recommend designing and crafting an estate plan. So it is vitally important that I know all of these before I actually begin drafting. That's the reason that you know it's not legal advice, because legal advice requires that you do that work. This author may or may not have been intending to write about a revocable living trust. And the reason is because it's not clear from the context, at least of this particular question, that he was directing his advice to those with revocable living trusts. That's going to become clear when I actually analyze what his advice is. But this does happen sometimes, that articles are disconnected from the manner in which they are titled or headlined in order to get readership. It wouldn't be surprising to find that the person that wrote the headline for this article included Revocable Living Trust in the headline because revocable living trusts are the most popular trust in America. And because it's the most popular trust in America, the most people possible might be interested in this particular article and read it. And of course, that is the goal of a publisher. It is not necessarily to inform as many people as possible. It is to get as many readers as possible, as many clicks, as many eyes, as many subscriptions. And that sometimes doesn't serve the interest of the consumer. Most of these articles have disclaimers. I imagine that picking 63 Corvette, Harley Chopper, or a prop plane was intentional, because those are the types of terms and items that, especially on the internet, are likely to pick up somebody searching, and that would cause them then to see this particular article. I'm very disturbed by the statement that all you need is a simple written instruction to transfer the title to a beneficiary. A simple written instruction means writing it down that that's what you wish. Simply writing on a piece of paper, I want the 63 Corvette to go to my daughter-in-law. Now, that would be something that would not be effective in most states. It would either have to be in a will or it would have to be in a title document, because most states have titles for motor vehicles, and certainly for airplanes, every airplane has a title, and the record keeping necessary is anything but what I would call simple. In other words, even if you're doing a simple transfer on death designation, and some people will consider that simple, to a single beneficiary, that's going to take paperwork, and you're going to have to prosecute that through either the state or through the federal government, depending upon what the asset is. And it's not a simple written instruction. Now, if a transfer upon death designation is considered a simple written instruction, that might be appropriate. But again, I think most of my clients are going, and most of the people I know are going to misinterpret this. And I see this all the time. I see all the time estates where somebody has made what is actually a simple written instruction, believing that it is enforceable when it is not, believing that it's dispositive when it is not. And so I generally do not like saying any type of characteristics like simple written instructions. Transfer upon death designation to a single beneficiary is as simple as you can get once you actually go through the hoops of creating the transfer upon death through the titling system. The problem is that's not in any way, shape, or form avoiding probate as a plan. It may avoid probate if that person survives you, but it may not avoid probate if that person doesn't survive you, if they are disabled or incompetent at the time of your death or after, if they're going through a divorce, if they have creditors, if they have any other type of situations that they're receiving government benefits that might cause there to be legal contest to them receiving the particular asset. And as a result, it's simply not a good plan. And that gets me to the last observation that I'm going to make with regard to the specific statement. And that is that it is obvious in looking at this whole article that this particular author only sees a revocable living trust as doing one thing, and that is avoiding probate. Everything this author is talking about is simply avoiding probate. Revocable living trusts are complicated documents. And yes, the primary purpose that a revocable living trust serves is to avoid probate. And many people buy revocable living trusts from third parties, particularly online, on the internet, or from mass media sources that primarily provide a trust that avoids probate. Many of these trusts are so simple that the only advantage of the trust is avoiding probate. But of course, I don't know very many lawyers that provide these types of trusts, and I don't know very many reputable programs that provide these types of trusts. Even the programs that are on the internet, such as LegalZoom and Trusted Will, provide at least a marginally more sophisticated trust. That's the reality. I'm not saying that I like those documents or I don't like those documents, but the truth is, even those documents from the most reputable online sources have more than a simple probate avoidance trust. They still are very popular, though, and there's still a lot of lawyers that don't do broader estate planning or don't do trust administration. They simply sell trust. None of those are my clients because I haven't had a single client in the last 20 years that told me there wasn't some other objective that they would want to accomplish with a revocable living trust. So let's talk about those. The biggest problem with the recommendation not to put an automobile in a trust is that it loses the lifetime benefits of the trust planning. And the further that you get away from funding your trust, the more that you impair the lifetime objectives of a revocable living trust. So let's talk about what some of those lifetime objectives are. And I have to tell you, they fall into two categories. One category is that a trust is the best way to accomplish the lifetime objective. The other category is that a trust is the only way to accomplish that lifetime objective. So you need to keep clear that although all of these lifetime objectives are going to be accomplished with a revocable living trust, some of them can only be accomplished with a revocable living trust, while some of them are better accomplished with a revocable living trust, even though they might be accomplished in some other way. And we'll talk about that as we go through. So the most prominent lifetime objective of a revocable living trust is consistent management and control of your assets. Most of my clients want their trusted advisors, their spouse, their children, whoever they want as the people that will take care of them as they age, in control of all of their assets. And as a result, they want lifetime control to be consistent. Now, this is best accomplished with a revocable living trust, and there is no question about that. There is another document that is used when you don't have a trust that tries to provide consistent uh, control and management of assets, and that is a general durable power of attorney. Now, it's no should be no surprise, and it's no mistake that every revocable living trust package that I know of provided by a competent lawyer also includes a general durable power of attorney. But I'll be candid with you that in my plans, a general durable power of attorney is designed to manage things outside of the trust. Those are things that can't be put into a trust, meaning the post box. If you want to change mail, you need a general durable power of attorney in order to change an address or hold mail or to redirect mail, to deal with any type of utilities, especially those of a municipality. You can't put the municipal water service in your trust, so you need a general durable power of attorney. And then, of course, anything with debts. We never put debts in a revocable living trust. The most common debts that most people have are credit cards. The credit cards, we don't put them into a trust, obviously, but we do have a need if something happens to us for someone to negotiate those, and a general durable power of attorney can do that. And that's really why when we have a trust, use a general durable power of attorney. By the way, the best example I can give you as to why you really need one, even if you think all of these things are silly and simple, and these shouldn't be that big a problem, go ahead and try to turn off your cable service while you're in a hospital for 3 months or 6 months, because it's darn near impossible. You would think that your cable service is the keys to Fort Knox, because somebody can't do that simply. And even with the general durable power of attorney, that's actually one place we find difficulties enforcing a general durable power of attorney. And that gets into the next issue, which is that general durable powers of attorney, when they're used for broader things like management of your automobile or management of your liquid assets, don't do a good job. It's why we choose a trust. The biggest problem with the general durable power of attorney is that in most states, it is a document of comity. And I don't say comedy with a D, I mean comity, COMITY. What that means is that when I present that document to a third party, I'm really trusting that third party that what they're going to do is accept that document, and they're going to do what I want to do when I provide them that document. But general durable powers of attorney make that difficult. They are creatures of state law, and state law has different rules and regulations with regard to how they have to be created, and different rules and regulations with regard to how they are to be interpreted. And of course, the document themselves, because they are only a creature of comity, meaning that there's no compulsion by the state to make somebody accept a power of attorney, creates its own problems. I tell folks that one of the reasons that general durable powers of attorney are often rejected is because of the age of the power of attorney. Or sometimes it's rejected because of the person that is appointed. In other words, if the bank has a person appointed by your general durable power of attorney that they don't know, or that they've never met, or that maybe they've had another person in your family that they have met and has accompanied you to the bank, they may assume that that's the person that you would prefer to have as your agent. They may reject your power of attorney. We also find that poorly drafted estate plans sometimes create this problem because, as you probably know, when you fund your trust, you're going to provide a copy of your trust to your bank, and they're going to have your trust. I find that poorly planned documents, some that are provided by third parties and really bad lawyers, they look at a trust and a general durable power of attorney as being two different types of documents. The general durable power of attorney, by some, is seen as a lifetime document, whereas the trust is seen as a death document, like a will. Nothing could be further from the truth. Your trust is a lifetime planning document first and foremost. That's what it does the day you create it, and that's what it's going to do until you pass away. It is going to manage your assets. If you become incompetent, if you become incapacitated, if you become disabled, or if it's just inconvenient for you to manage assets, your successor trustee can manage assets, and that is during your life. A general durable power of attorney is only a lifetime document. And of course, it dies when you die. In other words, the general durable power of attorney can't direct assets at the time of your death. The bottom line is that these documents sometimes are drafted inconsistently. And now you've got a bank who has a general durable power of attorney nominating one person, but the document that they've had in their vault for the last 10 years, which says that the person that you most trust is a completely different person. And that alone can create problems. Conditions of documents. People ask me sometimes why I put estate planning documents in a 3-ring binder. Well, that comes with experience. If you've ever seen estate plans that don't involve trust, you probably recognize them because they're either in folders with all of the documents stapled, or they're in envelopes. Imagine over 10 years what a document that has been repeatedly taken out of an envelope, unfolded, unstapled, then restapled, then refolded, then put back into the envelope is going to look like. It's going to look like a tattered mess. And third parties will reject these general durable powers of attorney that are treated such for just that reason, because they look like they're fished out of the garbage can. And that gives them obvious cause for concern. There are other ways, which are joint ownership and powers of attorney that are specific to an institution, but powers of attorney with a specific institution don't always work and don't always solve the problem, and they can create their own problems if they're inconsistent with other documents. That joint ownership is always problematic, and before you ever put any asset in your name and anyone else other than a spouse, you need very careful legal advice, because there are many unintended consequences of ownership that people simply don't think of when they put assets in two persons' names. I don't advise generally my clients to have their children on their assets. I don't advise my clients to have third parties other than a spouse as an owner of their assets generally. Now, there are obviously situations when that's unavoidable and when it's necessary, that the trust is the best way to have control and management of assets over a lifetime. The second lifetime uh, goal or objective of my clients is to avoid guardianship. And the reason that a trust avoids guardianship is because it has a successor trustee who will be able to manage all of your assets, if all of your assets are in your trust, at a time of incompetency or incapacity. Now, again, the trust is, in my opinion, the best way to do this, but there is another way to accomplish this, and that is by way of, again, a general durable power of attorney. But as we mentioned, the general durable power of attorney is not a good way to accomplish lifetime asset management. It's particularly not a good way to avoid guardianship. And the reason is that it only avoids guardianship for that is occasioned by your family seeing a necessity of having a guardian appointed in order to manage assets that the family can't manage otherwise. In other words, the only guardianship that is avoided is the guardianship that is started by your family. But there are guardianships that are established by other people and for other reasons. And these are innumerable. Your neighbor can ask for the appointment of a guardian. I tell folks that in the 1970s, it wasn't uncommon for people that were unhappy with a single mother with children to use child protective services in order to, I guess, demonstrate their displeasure with a single mother that they had a run-in with. Well, we do see in the modern age this visit upon seniors. In other words, your neighbors that don't like you, the way you drive, or like your music, or like the way you yell at their kids when they come on your lawn, if you're one of those seniors, they may ask for adult protective services to visit you. And we see guardianships established by adult protective services, by nursing homes, by assisted living facilities, by independent living facilities, by any third party hospitals, any third party out there that claims that you are a danger to yourself or to others, or that you're demonstrating abnormal or aberrant behavior, can ask for an evaluation by an appointment of a guardian. And the probate court can appoint anyone as a guardian. At least in the state of Ohio, the court is to prefer the person that is nominated by your general durable power of attorney. But keep in mind, that's only a preference. The reality is the court determines who is your guardian, and the court determines the circumstances under which a guardian serves. If you want to know how difficult and why this is an important issue and why you should want better protection than what just a general durable power of attorney provides you, go to the National Association to Stop Guardianship Abuse. Or if you want a specific instance, go watch the video of Esther Verone explaining her situation where she was under a guardianship that kept her in a nursing home against her will, basically imprisoned until court allowed her out of the nursing home in order to visit her only daughter. And watch what happens when she realizes, when on one of her daughter's visits, she visits her home to find that her home is for sale and that all of personal property in the home has been gone for who knows how long. And she was never advised of any of these things. So guardianship is something we want to avoid in a broader estate plan. Almost all of my clients want their family members to be the only people that make decisions for them. And so this is another objective that is best accomplished with a trust. The next advantage of a trust, and an advantage that can only be accomplished with a trust, is protection of the assets from a third-party court-appointed guardian. And let me be clear. I mentioned in the first example, in the previous example, why a trust could discourage or make less likely a guardian. But what happens when a guardian is appointed? When a guardian is appointed and your assets are not in a trust, the guardian controls those assets. In most states, the guardian controls all of the assets of the trust just by being appointed. But in many states, what are uniform trust code states, like the state of Ohio or the state of Missouri, we can draft a trust carefully so that the assets in the trust cannot be managed or taken or controlled by a guardian. That is not something you can get with a general durable power of attorney. It is a goal that can only be accomplished with a trust. I'm not going to go through all the benefits of doing this when you have a contested guardianship, but the most important of these is that by segregating assets from control of the guardian, we may make the guardian disincentivized. In other words, guardians only serve when they can get paid. And when we can reduce the amount of assets that a guardian can control so that the guardian can't receive large payments and control large sums of money, a lot of guardians simply aren't interested in serving. And that nicely disincentivizes a guardian from controlling your assets. So the trust is the only way to accomplish that. The last objective that is a lifetime objective that some of my clients, and these days it is more common for my clients to identify this as the most important objective of the trust, an objective that even exceeds probate avoidance, because after all, probate avoidance occurs when you die. But this lifetime objective is aging in place. The simple idea that you don't want to be in a nursing home or assisted living facility. You want to age in your own home as long as it is possible, as long as institutional care is not necessary, and that objective is only going to be accomplished with a trust. Now, I once spoke at a seminar where I was talking to lawyers about trust planning and aging in place. And one of the lawyers said to me, well, why can't we do the things we do in a trust with a general durable power of attorney? And my answer to the lawyer was this: you can try to fill up a general durable power of attorney with the type of guidelines and directions that you put in a trust. You can do that. The problem is that because general durable powers of attorney are such regulated documents by the state, I don't know whether any of those things are enforceable. I don't know whether any of those are going to be followed. And more importantly, I don't know whether putting those types of things in a general durable power of attorney is going to make the document even weaker. And what I mean by that is that by putting provisions in a general durable power of attorney that third parties are not accustomed to seeing, it may very well be that they're more likely to reject the document out of hand as not being enforceable. So, as a consequence, any of the directions and decisions and restrictions that we put in a trust with regard to aging in place are best provided there. And more importantly, because of that, it's the only way you can really do any type of aging in place. Because one of the goals of aging in place planning is making sure that third parties, like a court appointed guardian or a nursing home or a hospital, can separate you from your assets. Because the moment that they can separate you from your assets, then institutional care almost becomes necessary. So we want to protect our assets as much as possible by lifetime control and management of your trusted family members in order to age in place. And as I've mentioned, as I've gone through these lifetime objectives, this is only provide aging in place is only accomplished with a well-designed revocable living trust. So we've talked about the lifetime objectives. So let's talk about the probate avoidance. As I mentioned, I think that this article was only talking about probate avoidance as an objective, but even that objective is not best accomplished by a transfer upon death designation. Why? Because transfer upon death designations don't always work. I'm not going to go through in this video a long dissertation about why they are so weak and why they are dangerous and why, particularly when you have a trust, you don't want to use them. I'm simply going to refer to the articles, a series of articles that I've written regarding beware of direct transfer designations. Direct transfer designations is the broader characterization of TODs, transfer upon death designations, PODs, payable upon death designations, and beneficiary designations. The bottom line is these have significant risk and have significant disadvantages and don't always work. So they don't make sense when you have a trust which doesn't have the same disadvantages, doesn't have the same limitations, and always works to avoid probate if it is properly drafted. So let's talk about the only other issue that the author raises, which is you're exposed to lawsuits over accidents which involved the vehicle. So a revocable living trust in most states is not asset protection. It does not protect assets from any creditor. My revocable living trusts come with a statement that I provide to my clients, which says that a revocable living trust is not and should not be seen as an asset protection device. The revocable living trust is generally going to provide that all of the assets that you put into it are to be provided to meet all of your needs, including satisfying any of your debts. Okay. So in the first place, whether a car is in a revocable living trust or not in a revocable living trust makes no difference, because if you're going to have a liability with that car, okay, you're probably not going to have your revocable living trust as protection for you. You would have to do something more, such as a legacy trust in the state of Ohio or an irrevocable asset protection trust in most other states. Okay, state of Ohio, you can use a garden variety domestic asset protection trust, but the legacy trust has some advantages over what would be a garden variety domestic asset protection trust, and I would prefer it in the state of Ohio. But the bottom line is these trusts are different than a garden variety or even a sophisticated revocable living trust. In the first place, they're all irrevocable, which means that we get the advantages of the asset not being you, not controlled by you, and not being available to meet your needs, whatever those needs may be. And as a result, they're not available to your creditors. If they are available to you, if they do meet your needs, if you're able to take anything out of it that you possibly want, well, guess what? So can a creditor. The creditor can exercise the same rights that you have with regard to an asset. So the analysis that you're going to have liability doesn't make any sense. There's one other possibility that that I want to address that the author may mean, and I just want to be sure that I'm being careful. The author says that you may be exposed to lawsuits over accidents that involved the vehicle. Okay. Um, and it's I don't think this is what the author is saying, but what the author may be saying is that you're not responsible for accidents when the vehicle is operated by third parties, but by putting them into your trust, you may be. Okay. So let me kind of break this down. And this isn't necessarily an improper concern, but I don't think it's a big concern. And let me explain why. So in some states, okay, and this is what I'm told, every state I've ever investigated that somebody told me that this was true for, I found out that it wasn't true, that there was not, that the state did not have liability that followed the automobile. Liability in most states, in the states in which I practice, it certainly does. It follows the driver of the automobile. The only time that you can ever be responsible for a driver other than yourself is if it is your spouse and you have an obligation to support your spouse, or it is a minor child. An adult, such as your neighbor who borrows your car, if they're involved in an automobile collision, even though it's your automobile, you're not responsible for the liability of that automobile. But I have been told that other states that's true for. In fact, the state that I was first told that was true for was the state of Michigan. And I was very interested in that observation by a Michigan council when I first started practicing, because as you could probably guess, in Ohio, I have clients who are either own assets in Michigan, or I do have clients from Michigan who come over to the state of Ohio. There's very specific reasons that Michigan clients may want an Ohio trust. And so I was concerned about this particular issue. But I found out that it was really an insurance issue. And the real reason that a lot of lawyers didn't advise putting automobiles in trust wasn't because of liability, it was because of bankruptcy. And that made a lot of sense. The way that Michigan's bankruptcy laws were at least drafted at that time. But I'll be candid with you. I don't know that there's a single state where the liability follows the automobile, meaning that you're not liable, that you're liable if you own the automobile for anybody who might be operating that vehicle. I just don't know that that's the truth. I don't know any situation where that's the case. But even if that is the case, okay, keep in mind that liability is the automobile's. If the automobile and you're the owner of it is outside of your trust, how have you solved the problem? You haven't. Unless you had a domestic asset protection trust, okay, an irrevocable trust, then it would make sense not to put an automobile in those states into your trust, because liability could befall an otherwise protected trust in the event that there was an accident involving that automobile. And that may be the limitation of where this particular analysis might be right. Because in that situation, putting the automobile in a trust to accomplish that objective is in cross purposes to that objective. Now, I will tell you that in every client I have that has a domestic asset protection trust or legacy trust, guess what they also have? A revocable trust. Why? Because we have assets that we either don't want to protect, need to protect, or that don't have value worth protecting, that we simply want to accomplish the other lifetime objectives for. and we put those into the revocable trust. So all of the personal property, for example, we don't put all the personal property in the irrevocable trust because the irrevocable trust has a much, much more refined management structure. And we don't want to have to go through that management structure in order to dispose of, say, the refrigerator or tables or chairs or paintings in your home. So as a consequence, we almost always need a revocable living trust. I don't know how other lawyers work that particular situation, but I provide the revocable living trust as part of the cost of doing a domestic asset protection trust or a legacy trust. So it's not even a question of whether you want to have it. It's part of the cost of doing the trust because it is necessary to do a complete estate plan. I tell people all the time that if you have a legacy trust or domestic asset protection trust, you should also have all of the other documents that make up a complete estate plan because these may reduce your liabilities. For example, having a general durable power of attorney for healthcare may reduce your need for medical expenses because you may get better and quicker healthcare decisions. The risk of your disability are reduced by having quick decision makers. And if somebody has to go through a longer process in order to get healthcare decisions made, that increases your risk of disability. I don't think that that's a significant risk for most people, but the truth is it's foreseeable. And that's why I want all my clients to have a durable power of attorney for healthcare. By the way, if you're watching this video and you're not a client of mine, we do durable powers of attorney for healthcare and living wills free for anybody who asks for them. And the reason is because we think that it is so fundamentally necessary for everyone that we don't even want the cost of a small nominal cost to be a barrier to everyone having them. We used to do seminars in churches and social organizations where we would go to the organization and we would simply sign everybody up. Everybody that didn't have a healthcare power of attorney or a living will, we would provide them free of charge right there at the institution that we were performing those seminars. I haven't done one of those in a while. If you are somebody that is affiliated with a large organization, such as a church or a social organization, and you want my office to do that, give me a call because we'd be happy to do that for you. The bottom line, though, is that I don't think that that is a significant risk for most people. And more importantly, I don't think that this is enough of a justification for me to say that this is proper advice, at least for my clients. If you are a member of the public and you don't know what your revocable trust does for you, if you don't know whether the trust is probate avoidance only, or if it provides lifetime benefits such as guardianship protection, asset protection from guardians, aging in place, or other lifetime benefits, you need to speak with your advisor, whoever your trusted advisor was that got you that trust. Hopefully it was a lawyer. If it's a lawyer, you can simply call the lawyer and say, listen, what are the advantages of the trust? The lawyer should have provided you with something that indicated the advantages of the trust, or you should have known those going into the trust process. I know I ask all of my clients. My understanding is that you're, other than the management and distribution of your estate, which we accomplish first in talking about their estate plan, is the management and distribution of their estate. We talk about what their other objectives are, and that most of my clients, their primary objectives are probate avoidance, making things easier for their spouse and their family if something happens to them, avoidance of guardianship, a short way of saying that you don't want third parties involved in your assets or in your decision making, and aging in place, a short way of saying that if you had your preference, you'd rather be at home than in a nursing home or an assisted living facility. And there are other specific objectives such as reducing the risk of contest in the right situation, the management of assets for minor individuals or for people who are disabled, management of assets for those who have special needs, management of assets for those who have addictions such as substance abuse or gambling addictions, those types of impairments. There are a variety of other specific objectives that a client may have. And of course, all of these are determined in the course of legal representation. So if you don't know what your trust is doing for you, you need to figure it out. And then you should be funding your trust properly so that you can accomplish the objectives of your particular trust. You may not want to accomplish all of the lifetime objectives that I've mentioned today. You may have a trust that has a more simple purpose. And if that's the case, then you can make simpler decisions with regard to how you fund your trust. But I want my clients to have all of their assets in their trust. I want to make one quick note. In the state of Missouri, we don't use title transfers when we're funding a trust of automobiles. We use transfer upon death designations. There's a reason for that. The state of Missouri has made it very difficult to do transfers of automobiles to a revocable living trust. And because of that difficulty and because of the cost and expense of going through that process, we simply don't want our clients to go through it. What we find is if we make them go through that, most of them aren't going to complete the process and their trust is going to be left unfunded. So we have sacrificed what is my first choice, which is to have the automobile put into the trust. And what we've done is we do a transfer upon death designation to a trust. Keep in mind, that is not what this author says you should do, because the author specifically says you can make a simple written instruction to a beneficiary. Maybe they're not talking about an individual. I think that's what they're talking about. But in my situation, I don't want it to a beneficiary other than the revocable trust. And then the trust will define who the beneficiary or beneficiaries of your estate are. And that's at least a compromise in the state of Missouri that is workable. I do tell my clients, though, that if they have an opportunity when they buy an automobile to have the automobile transferred into their trust as an owner, meaning that a dealer is going to do the work for them and prosecute the paperwork correctly for them, then you should do that. Now, I find that what I hear from my clients is that most dealers won't do that for the same reason that my clients won't finish the process, is because it's difficult. But I at least want my clients in there doing it. And I know of at least one instance in which a dealer did do that work for a client. I suspect, though, that a lot of the reason that the dealer did that is because it was a very, very expensive purchase, and the dealer just wanted to make this particular client as happy as possible because they knew that there might be future purchases, and so they went the full 100 yards for the client. And and they may not do it for other clients, but at least ask if you're in the state of Missouri. In conclusion, trust planning is not simple. It is not an unsophisticated estate plan. A lot of people treat it as that. And more importantly, it is a more evolved estate plan than what was commonplace 20 or 30 years ago. We used to say when I first started marketing estate planning that you should put you back in your estate plan. And what that meant is that there was a time in the past where people were only concerned with what happens with their stuff when they die. And that shouldn't be your only concern. In fact, it shouldn't even be your most significant concern. If you can imagine, as I mentioned previously, probate occurs when you die. It doesn't affect you at all. It only affects your heirs. But what happens between the time that you begin your estate planning process and the time that you die is very important to you. It is all about you. And that is why we tell clients to put you back in your estate plan. Your family should know what your wishes are, not just what the wishes are when you pass away, but during your life. One of the reasons we do an advance directive for dementia, Living wills deal with what happens when you die, what happens with your body, what happens with the determination of your death, what happens with regard to providing you with mechanical support as you are ending your life. That's what a living will does. But an advanced directive for dementia talks about how you are to be treated and how you're cared for during your life. And every client, in my opinion, should care enough about what their circumstances are and how they are going to be treated in order and have a advanced directive for dementia in order to accomplish that. Those are lifetime objectives. If you have a trust that is so simple that it's only avoiding probate, you want to seriously consider updating it, renewing it, reinvigorating it in order to do something more, because trusts are spectacular documents that can do spectacular things in the hands of good designers and drafters. I want to thank you very much for watching this video. I hope you liked it and I hope you find it interesting. If you did, please like it, subscribe to the channel, and share it with your friends. I hope you all stay safe, be well, and God bless you. I wanted to add a quick postscript for the very reason that when I was titling this, it was awkward. And so I wanted to use uh, trains, planes, and automobiles because of the movie, and that just seemed to ring well. But I wanted to let you know that that's actually a real situation. I've actually had two clients that have had an interest in a train. The first was a client that lived in Worcester, or near Worcester, and they actually had a small riding train complete with engine and cars that the client had erected in their backyard. And now it wasn't a full-size train, but it was a train. Another client, a wonderful, wonderful woman, that it's hard to imagine a person that had more thought and concern for other people. She was just amazing. But she actually went to the effort, since she worked for a railroad during her life and retired with a railroad pension. She went to the effort of buying a boxcar and having it moved to one of her rural properties, and I believe in West Virginia. Maybe have been in Ohio, but she had property both states. But she wanted the car to be placed on one of her properties, so she actually acquired a real train. So although the article that I'm referring to doesn't mention trains, I thought I would go ahead and let you know that it is true that clients do sometimes have an interest in a train, both model and by the way, the one that was in the backyard for my client who built and constructed his was large enough to ride. It was a working model of a train that was large enough that kids could get on it and adults could get on it and actually ride around his beautiful, beautiful backyard. Um, just just so you know. Uh, so estate planning, when you actually do it over a long period of time, you see everything. And so, yes, the article is not just wrong for automobiles or prop planes, as is mentioned in the article. It's also incorrect for trains. I hope you have a great day. Thank you. Bye-bye.